Hi, chat. And no, he was not stuck in the bubble wrap. I just taped him up in the box. I had to put him and Lainey away. So, how are you guys doing? Welcome to the show. Do I hate you guys? No, not necessarily. Not necessarily. No, do not mirror my camera. There we go. That's better. That's better. Been a long day. Got a lot of work done. Actually, had to get some stuff prepared. I got to fix the... we had to put railings on the stairs for our deck. So it's up to code. Get a couple things fixed up, and that's the game. So, welcome. I am so sorry, guys. We were busy. And part of that busyness was the internet fighting me for the thumbnail. And then I had to open up the box he was in. He'd like, fat man, help. And you can hear Lainey. She's still stuck in a box. I just hate you sometimes. I mean, sometimes, yes. But remember, chat, it's always your fault.
Always blame chat. When Sean doesn't share the screen, your fault. When you hate the Jannies, you're the Janny.
And you know, as it shows you, there is an ABC on there, but there's also a CLYDE. Oh, my body. Yeah, we had a big thunderstorm earlier today, and Clyde was very, very scared. It came through fast, though, and I think that helped. I know. It's okay, Papa. He misses 2.0. She'll be back. So I'm going to set you on the ground, okay, Butter? Okay? Okay? You're getting long. You need a haircut, too. Say, I do, too, but I had to give up my haircut yesterday because I had court, and I was like, shit. Thankfully, I could get a cut before I go to Florida. But, oof. But as you can see, guys, the move is real. We are moving. All kinds of shit's loaded up. I mean, I'll show you guys real quick if you don't believe me. Just look. Look at everything is loaded. We're getting loaded here, guys. This is part of that room you've never seen in the Beat Lab from this angle. I mean, like, all the panels are coming down. Everything's happening, chat. Everything's happening. So, yeah. It's for seriousness. Oh, I'm gonna hate Swamp Ass. Of course I am. Have you packed up the dildos yet? What? Like, no. Those get packed right before we leave. Joe says, how are the cats doing with all the cat traps? They're doing pretty good. The cat traps are working as intended. Final Revolution says that United 727 better have all the bubble wrap. I don't know, because I was not here when it got packed. I was actually out during the day. And I came back and that was packed already. So I don't know which box it's in, but I know I had a bunch of closed cell foam that I've accumulated from when you guys send me stuff. And I'm thinking it's packed okay. I don't know. But yeah, I'm very worried. I just don't want to start digging through all the boxes to look for. I'm just going to leave everything the way it is. We hired a good moving company and everything. Jim, how you doing, Jim? Yeah, loading up the truck and moving to Miami. Not Miami, but over on the East Coast. So I'm still in the Florida of the North. Yes, I'm not leaving until the end of the month. And I have a couple of court dates that are like right at the beginning of June that like the judge is like, you know, your case might end by then. Like, are you sure you can't like stay? Because I don't like, the judge is like, do you have to be down there? And I'm like, well, I'm not licensed. They're like, oh, so you could be here for a couple of days. And it's like, I guess. Like, your house isn't under contract yet, is it? And I'm like, no. You can't lie. Can't lie about it. So whereabouts in Florida? East Coast, up kind of like in the central, the northish part. So Afton says he doesn't look like he approves of this plan. Clyde doesn't approve of anything that he's not in charge of. Pepsi Man, been a member for 12 months. Says, how was everyone's weekend? I know. How did your weekend go? And could be worse. You could be trying to sweep for Melanie Mack and fucking Jeremy. I mean, of all the people to sweep, sweeping's bad anyway. But you're sweeping for fucking Jeremy Hambley and fucking Melanie Mack. Like, there's far better. I mean, it's never good to sweep, but if you're going to sweep, I hope you're getting paid well and compensated well, or it's for somebody that's huge. And if you're not doing that, then why are you doing it? I mean, unless you think you're doing it on principle, which is okay, fine, based, you stood on your business, but I don't see like Melanie Mack and Chrissy Mayer standing on business like that. They don't really have business like that. Melanie Mack's business anyway is, grifting a false prophecy and blaspheming. And it's not as bad as well, actually, I don't know. I mean, does Melanie Mack believe that Jesus is the only son of God? And that, through him, only through him does salvation lie. I don't know. I don't know if she's as blasphemous as Nick Rekieta, but it's still pretty bad. So we'll see how that goes. But yes, they are imploding. Darth Botto says, did I move yet? No. We, Ohio, miss you already. Yeah. Which means if I'm around for the week afterwards, I'm going to be here when the train rolls through. The 404 or the 4400 will come through. And that's going to be like a couple miles from my house. So I may be here to watch that and then head out. I don't know. We'll find out. Did you mean to make that guy look like Pete Hegseth? No. Poor Lainey, did you give her the drugs 2.0 said you got for her? Yes. I gave him to her earlier. I don't know if I can give her another round yet, but there's a dog outside barking too, so she's up there. Amateur Iconoclast is up to code. Isn't the next guy's problems? We already had to get him done as part of our, it was weird because at the beginning of January, our homeowners policy, sent a letter and saying, hey, you guys need to put railings on your stairs. And we're like, how the fuck do you know what's in my backyard? I don't know if they use satellite footage or what, but they did. And they said, you've got till mid-February to get something up. So I went to Menards and got some 2x4s. They're just and I fucking did it construction style and just, went off the posts that hold up the railing on the edge of the deck and just, it looks like we're on a fucking job site, and they work. And they said they wanted a permanent solution by the end of the year. Well, obviously we're not going to be here by then, but also we were told that's to help keep it up to code. We're going to have to do that. So, it's just going to be a pain in the fucking dick. So I'm just getting it done because for $100, I got 2 railings, and I'll just get them done. I don't need the people we sell this house to trying to nigger us out of a couple $100 or $1,000 for fixing things up. If I can put some time and effort into getting stuff done, then they can't bitch at us. At least my thought. Do I know what the oranges are for? Yes. Oh, let's see. Only the Baldos are packed up. Yes. Adjective, noun. Yeah, I saw that. Yeah, there's nothing wrong with eating tendies. I don't know. It's smart to leave. No, it says smart to leave before the jeetoning takes place. Yeah, I'm not, Ohio will always have a place in my heart. But honestly, if you read Camp of the Saints, none of us are safe from the jeetoning. That's going to happen no matter. The Camp of the Saints didn't end with all those boats being sunk. So, we're on our own until Pakistan nukes India, which, fingers crossed for that. Yes. Who was it that tried to catch the flight in the Frontier plane? Oh. Yes, that is the best. Yeah. So some guy out of Denver airport, was on the runway and the fucking airplane's taken off and just threw right in the engine, fucking sucked him up and just. So, I don't know how, I don't know how you get on the runway out there, but you do. So I don't know. Maybe he escaped from the underground caverns where they do cannibalism and shit that allegedly occurs underneath Denver Airport. And Tejas Liber says, hey, Sean, I watched your previous show and you finally explained why in video games there's always some random car or house that's inexplicably has random ammo. Or magazines for rare guns. Yes, I know that's the funny part. Yes. So, Booch says, "Oh, Miami? No, I don't. We're gonna be way north of Miami. I'm gonna be a couple hours away from Miami. So, not to worry. Tejas is like, yeah. Why does this random hatchback have AUG maps? Well, it's technically not a hatchback, but it's like it's an Ascent, Subaru Ascent. So it's kind of like an SUV-ish thing. Am I going to take a coffee can to pee in? No, I'm going to like pull over on the side of the road, pee in every state on the ground. Mark my territory. The judge is like, we need you, fat man. Why? No, if they could avoid having some because I've talked to a couple, attorneys, they could take some of these cases over, but they'd rather not having a new attorney get caught up to speed. Or like, can you resolve your shit? And I'm like, all right. I mean, well, I guess. So, will there be robberies on the way down? I'm not going to say exactly where. I'm sure you guys will figure it out anyway at some point. But no, we don't make a habit to intentionally dox because, you can find out. Houses are being bought and sold all the time. So if I tell you where it is, you guys would find it. And we like to stay anonymous to an extent, especially 2.0. I'm moving to Jupiter Island. Yeah, I'm moving. Boca Raton. That'd be nice. I did sweep for Nick. When did I sweep for Nick? B Jammin says all my Warhammer paints are completely fucked. Help. Well, I'm sorry, brother. Although I will say, especially with now that I have time to get everything organized where we're going, this thing Stabby sent me of I believe this is Sanguinus. And we're gonna do. I plan on getting a resin printer, and I'd like to do some bigger Warhammer things. And I have the speed paints, and in addition to all the other army painter shit 2.0 got me, which has been really based in helping. Didn't know if I'd show you guys this, but we had one last set of guys I had to get together for bolt action. I have not had a chance to pedestal them, but I did get them. Sprayed with some clear coat, but it's a nice contrast because I finally found a paint color, and this is in their regular army painter colors, that gives you like the tropical color because it's like this weirdish green. And I think this is the closest thing I could find, especially when I oil wash it. He's going to be pretty close to their green when I oil wash it. But see, he already comes pretty close to, you can see how grungy they look when you get them going. But yeah, there we go. But yeah, no, there's some cool stuff coming, guys. I got some, we're going to do some cool shit coming up if I can get this resin printer shit to work. So MLS says Melanie Mack is a sweet goddess and she will be on my Lego stream. Yeah. I mean, the quartering is huge, physically speaking. Yes. Well, as am I. Has Jeremy started deleting videos? Well, he would dirty delete videos that weren't performing well. No, but he's deleting tweets. He started bitching about Gary basically disavowing Melanie Mack or disavowing Chrissy Mayer and what she did. And I don't blame him. Jeremy's like, cry gets a woke mob. No, it's people holding you fucking accountable. The community is policing itself. And Gary did a very classy job of it. But I like how Jeremy, fucking D-Day comes in afterwards like, fuck you, Jeremy, fuck you. And he just lays into him. And I'm like, good cop and bad cop. But yeah, I thought Gary did a phenomenal job at navigating that. Melanie Mack's business saying the word faggot. Yeah, I know. I could say it too. I just don't look cute. I probably have bigger tits than her, but yeah, I could say faggot and have tits. See? Faggot. Oh, there's nothing wrong with cocaine, nerd. Okay. the four. I'm sorry, I forget the number. I don't know the number too well. I'm really not a trained farmer. Yes, the 4014. Thank you, Lou. So, um, Apton says, can't they legally fly drones over your property? I don't. I mean, I would have noticed. And 2.0 works from home, so the dogs probably would have lost their shit if drones were flying overhead. So, casually dropping the N bomb. Well, yeah, you gotta. If you say it, it has no power over people. Hmm. Kathy, your realtor in Jersey. That's right, guys. Kathy is your realtor out in New Jersey. You want to buy, sell, rent, lease, do whatever it is you want to do with a piece of land. You want to do a fee tail. I'm sure she'll kill you if you try to do that. You want to do life, whatever it is. Kathy is your girl. Check her out in New Jersey. Hit her up. Definitely do the obvious, clean the windows in and out. We have already cleaned the outside of the windows. So, yes, we're going to get the windows cleaned on the inside. But basically, we're going to have moved out of here before, and we'll have the house put up as soon as we move. So, John Coleman says, since you're moving to Florida, can we not say gay anymore? You will just be late. There you go. Eric Eagle Eric says, you need to check out Ed Michelle from the Great Outdoors, or the Great Outdoors. Speaking of Ohio, yes, I have seen finally the casinos coverage of it, and the fact they dare, the fact that PPP wants to mock Ponderosa or Fun Buffet or whatever it is that's out there, yes, I'm sure Curryville and butter chicken. Oh yeah, you're showing me, bro. You're showing me with your Indian slop, sir. Yes. No, we have American slop. All right. All right. Let me just tell you. I'm not gonna let him tolerate. I'm not gonna let him do this to Ohio. Ohio is the shield of this great nation. It's even shaped like it, too. Just like in 300. On these shields! That's where all this bullshit from Canada goes. Just right against that shield. Can't hurt this state. PPP wishes the buffets in Canada were as fun as here. Something to think about. He's so jelly he could be on fucking toast right now. So, but Ohio is safe, clean, and crime-free. Yeah, but I wanted to level up. I want to move up to the next level where, I want to play on a harder mode in life. So we're going to go down where we're going to play on advanced mode. Was the guy running from the cops? I don't know when he got sucked into the airplane. Hi, 2.0. Hi, sweetheart. Hope you had a nice day. I don't know if you went and did anything else this afternoon after we talked. Are you going to make a trip to the Freedom Factory? I don't know which one you're saying there. Peeing on the ground is better than what low tier God does, or Jeremy. John says for $2, say hi to Donna Adelson for us. Yeah. Say hi to freaking Sarah Boone. And the neat thing is we'll be down there and set up by the time Courtney Clenny's trial kicks off. Carmelo Anthony, the jury selection is probably going to take a while. We're probably going to cover that live. Unlike other people, we're actually going to do it live. We're going to do it all day. So, where are you going to shit? I don't know, wherever I can. Let's see. Yeah, well, Keopathic says a lot of properties info is public. It is, but we just, I'm not going to tell you the address of where we're moving to. I mean, you at least try to make it a little bit hard, but yes, if you were to look around, you could figure out things pretty easily, but you just don't put it out there. You hope it's hard enough that lazy people don't go looking for it. So, let's see. Time TCT says, if you go east and south, detour to Gettysburg. Been to Gettysburg before. It's nice. Gettysburg is a beautiful place to go. Oh, that's Dante or the Sanguinor. Okay, well, Sanguinor, Sanguinis, I don't know. Aaron was retreated by the Frogman. Really? Wow. Does Florida have enough willow-bearing support? We'll find out. Uh, my problem is that I have 2 cans of the base color for my Space Marines, but masking where glue goes is a pain in the ass. I mean, just scrape the glue off afterwards. Like when I make these guys, you got to put their, shout out for the dude with the, when I made this guy, I just painted all of it. And then when the time came, just scraped off the spots where the glue was going to go and worked out. I mean, a couple times I've just glued over paint too. But if you're using like, paint that does the plastic like welding, yeah, just scrape it off and you're good to go. When is the joint stream with Noel at a local Bucky's? Noel's going to be a long time away. And yes, 2.0, yes, is right. Look for where the FBI offices are and you'll know where we're going. Meme said Jeremy's deleting a ton of shorts. Yeah, he deletes anything that gets no views because that way he could show a better view to advertisers. Make sure you get a dehumidifier for your resin print room. I will work on that. Well, that's going to be like, we're going to have this set up. Like, I'm going to have this table for like the streaming and doing work. And then for the model stuff, it's going to be a separate table. And I'm just going to have like a laptop and then I'll just hook the camera to that and you guys can see what I'm doing. That's going to be the game plan there. So, but yeah, it'll be all in the same room. But I gotta figure that out when we get down there. But I also need to talk to Stabby because he's like the resin printing guy. I know that does it really well. And I got to work on all the shit he put together for me, all the Warhammer dudes. Apparently, he deleted the Tism channel. Whoa. He's running fucking scared. He's running fucking scared, guys. Oh, no. Oh, no. Can Chrissy Marbury retire to the old whore ranch before they go to the glue factory? Yes. Oh. Malcolm says, you have an awful lot of train games for someone who's not a foamer. I know. It's weird, isn't it? Adjective noun says, do you feel left out from not getting a video taken down by Jeremy? Well, I haven't really done anything, yes, but yes, fuck you, Jeremy, you cock-sucking bitch faggot. There. Maybe you could take that down, Jeremy. Cry about that being harassment. Torgo says, I was traveling, missed Friday Night Tights. Check out Alyssa clips. She clipped it. Very well done. Are you going on a trip? Robert Lawrence says, no, we are moving to Florida. We are moving for reals. So, is Kathy mad I didn't buy New Jersey? I mean, I think she can understand. It's up there with like Ohio where people want to move to. Nobody really wants to move to Ohio. Afro Man doesn't use the N-word. Yes, he does. It's the Sanguinor, by the way. Okay, I'm sorry. Oh, yes, she is now the assistant special agent in charge of a FBI field office in Florida. She's been her work as a Fed has been very good. She's done very well at tard wrangling me and keeping me from parking a car bomb in front of a federal building. So they're promoting her for her skills. Please use a LawPo plate in Florida to get Nick some fan mail. I would not do that. God, that would get me in so much trouble. I mean, like I know you guys are like, oh, what happened to Dr. Steve is not a big deal. Well, that would be a big fucking deal. I would get they would be hollowing my asshole out with a weed whacker if that happened. So no. Fun Buffett only has 2.8 on Yelp. That doesn't matter. Doesn't matter. I don't care. Absolutely slopped, but that it is. That's what it is, man. I'm not going there for Michelin stuff. Are you? No. I'm the defender of Shoney's. I actually I've been to a Shoney's once. And where I was as a kid, where I grew up, we actually had a Ponderosa. And it was really fucking good, but I didn't realize my dad used to complain, though, because, like, they are so fucking, they're so fucking Jewish about everything there. Like, you can only get one pop, but my dad would always just go up and get more. He's like, fucking stop me. Do you think I'm a bit racist to Ramawama Gingong? He could suck my dick. So, I remember having a Bonanza way back in the early 2000s that was decent. Yeah. Yep. I'm trading the Haitians for the Cubans. Yes, and the Cubans are based. So, yeah. Oh, Florida's definitely advanced mode. Yes. Oh. Yes, Your Honor, the law doesn't say my client can't attack an alligator with nunchucks. Am I going to cover the catch-22 for the lawsuits that they filed? Yeah, we're going to get into that probably on Monday. Actually Monday or Tuesday, because we're going to talk about the Virginia stuff, but then also they're going to start suing in Florida, so it should be very interesting there. 2.0 was like, we went furniture. Yeah, she went furniture shopping. Holy shit, furniture is very expensive down there. Wasn't Carmelo in Texas? Yes, it is. I will now go to Gatlinburg. Yes. I've been to Gatlinburg before. My newest fear is sinkholes. Well, like, like I told you guys, if you read about like Creutzfeldt-Jakob disease and how it like eats your fucking brain away, and you're like, I'm never gonna be in a situation where that happens, you'll still spend that whole night like laying in bed, just like, oh my god, I'm gonna fucking die. Like it makes you scared. And yeah, that sinkhole thing is scary as shit. Like that one guy who was like in his bed in his house and it's sinkholed. Oh, that's scary, man. They never found him, I don't think. I don't think they ever found him. They just like I think they just fenced it off. So oh yeah, the base colored spray cans. Okay. Yeah, that could be a problem. Have you looked into what's gonna be the coolest bridge? I don't think I'm crossing. Well, I mean, other than like the Ohio River, I don't think I'm crossing any serious bridges. Well, actually, I say that because when I'm on I-95 probably crossing the James River down by Jacksonville is going to be a thing. And the neat thing is, I'm going to be going down. I think. Oh, hold on, I need to check the map here on this because I think I'm going to go by Kings Bay down in Georgia, which will be kind of cool because that's where the nuclear, the boomer fleet is. It's the U.S. Navy's home to the missile fleet. And let me see here. What's it going to show? Oh, here we go. So give me the course. Yeah, because what it does is I take 77 all the way down. I don't even go through Hotlanta at all, chat. I go through Charlotte on 77, and I go all the way down to Columbia, down to 26, and then I catch I-95 down like, wow, apparently it meets I-95 out in the middle of nowhere. Okay. And yeah, I will. Ooh, no, I don't think I do. Do I go by Kings Bay? No, actually, yeah, I do. I do. I do. But there's no roads that go near like where you can see the boats leave. That sucks. Damn it. Damn it. I was like, that'd be cool. Is 2.0 really a Fed? I'm convinced she's a Fed. It doesn't make sense otherwise why she hangs out with me. Oh, she likes me for me. No. No, no, no. No. That's too easy. I'm one of those people where hey, you're not important enough or good looking enough for a good looking woman to come find you. If a good looking woman's talking to you and is being kind to you, something's up. So no. Do I have a P.O. box yet? No. But I will have one set up down there, but I'm gonna have to get that done. John Coleman for Joe says, can you let Mal rent a room? No. No. Are you gonna go visit Castillo de San Marcos? Is that in St. Augustine? I don't know. Where is that? Yeah, that's the yes. Any Star Fortress is always cool to go see. I married a Fed. Well, yeah, her job is to handle me. I suspect she's a Fed. Do you see how Sean cowards when challenged to fight the system of EVS? He says he's got the cars. They have to get fucking signed and mailed out. That's probably another 2 years, man. Yeah, Reform got a chance to get some territory back, but we'll see. Hassan's not happy. Yeah, well, fuck Hassan. What did Debbie? Oh, what did you say? A tip on Florida furniture shopping. Mine came from estate sales. Ooh, we'll have to look for that. Ooh, yeah, that's a good idea. Anonymous is Suffolk porcelain pounder. Yes, I am avoiding Atlanta. Charlotte is okay if you miss the morning or evening rush hour. I'm gonna figure out. I'm just gonna go when I go. Hold on. Somebody say, can I schedule petting appointments? No. Okay. We're all caught up now. Are you seeing someone is doing a lawsuit against Jeremy? It was on Camelot stream. I no, nobody's really going to be able to sue him. There's not like, and Worski actually, and I don't know if Worski's talked to an attorney, but or Worski just recognized it because I've said this before. All you're doing in a lawsuit is you're taking a pile of money, you're taking whatever you have in your wallet, and you're shaking it out on the table, and you shove it in the middle, and you light it on fire. Like, what are you going to get out of it? Like, yes, Ethan Klein can burn money, and he's burning money to go punish people and fucking ruin their lives. Great. Like, that better be your goal. And then Ethan Klein could go make more money. Ethan Klein's got, like, TD Entertainment. Like, Ethan Klein makes a lot of fucking money. Like, do you have that kind of money? No. Like, you need fuck you money to do lawsuits. And if you don't fuck you money to do lawsuits, don't do it. And if you even do have fuck you money, you know what you could do to flex on these hoes and stun on these niggas? You go out and buy like a fucking Maserati. You go buy like a fucking you go buy a Mag 58 and fucking Pano nods or something. That's how you stunt on people. That's just my recommendation. A lawyer says he's doing a class action against quartering. I mean, that's not going to get anybody anything. Some attorney on Twitter is making demands saying he's doing a pro bono. No, he's not, because he's going to get fucking paid at the end. Because attorneys always get paid at the end, and the attorneys make all the money in a class action. So, nothing there. Adam says the Blake Lively lawsuit. I don't know. I heard that kind of collapsed and crashed and burned. Tenoch says, what's a Mag 58? A Mag 58 is the original designation for the M240. When FN, Fabrique Nationale, invented it and they developed it, it was introduced in 1958. It's been around for fucking ever. And then in the United States, it got adopted as the M240. You can't buy an M240 unless you have like a dealer sample and you run in your license and do all that. Private ownership of them. Some were imported they were imported as Mag 58s. So that's why they're called that. That's the, so yeah. There you go. What do I think of the Patrick Tomlinson settlement? Justified. Those cops violated his constitutional rights. They kept fucking breaking down his door, basically, and dragging him out at gunpoint when they knew it was probably going to be a swatting. They knew that it was fake, and they knew that it was gay, and they still did it anyway. Those cops should have been held fucking liable. Patrick Tomlinson should have been able to sue them into fucking poverty. Because those same cops will fuck you over on a traffic stop, and they'll fuck you over at your own house and violate your rights there. You can't trust those people. Those people should not be cops. So, oh, we have to go feed the fish over at Pima Tuning? Yeah, we'll do that. Debbie O for $5. Thank you, Debbie. Says, please become a Zoom immigration judge for Ohio while you wait to take the Florida bar. Then become a Florida immigration judge. Thanks for listening. I mean, I threw my hat into the ring there, but I don't know enough. I really don't know much immigration law, and I think that's something they're going to want a basic understanding of. And I joked about it, but I'm serious though. You guys probably wouldn't like me as as in a judicial position. A lot of things you'll support, but there's going to be a lot of times where I'm like, I'll make a ruling you're not going to be happy with. So I'm not just going to sit there and a flare. There's going to be a lot of people who probably do have valid reasons, or the way the immigration system has done it, they're entitled to relief. So I'm just saying, like, you guys say that, but I really don't think you'd want that, because I probably wouldn't end up doing a lot of things you guys wouldn't like. Now, honestly, I wouldn't care. I do them anyway, because, you do what's right because it's right. But I'm just telling you, like, it's, I would be very serious about it. Did you see the misspelling Virginia Democrats did in the appeal for the Virginia Supreme Court? Yeah, but I mean, dude, like everybody fucking misspells. Like I'm not gonna shit on them for that. Those things happen. A misspelling is a misspelling. Like when you work at McDonald's, a mess up is you put pickles on a burger or you accidentally put cheese on a burger when you're not supposed to, or you put ketchup on when you're not supposed to. When you're putting a brief in for the Supreme Court, you have a typo. Like, it's like, man, it happens. It happens. It's live TV. And time is of the essence. So, as long as you rule for the law rather than make excuses to keep people here who shouldn't be. No, but I think there will be times where, they'll be entitled to relief based on how the government's acted, because there are ways the government's handled this I have not been thrilled with. And the way they've handled some of these immigration matters is, I don't think is fair, and I think is bullshit. So we'll see. We would see. Now I can be like, I need to call Danny on and be like, hey, can you do me a solid and, use your name and throw it around in there? Oh. Adam says AI would have caught it. Yeah, but there's something said about not using it. Yeah. So they called it World War 11, so I'm surprised they're not spelling errors. Long King says, would you get disbarred if you misspelled stuff on purpose or for fun? I mean, no, but if you admitted to doing it, probably not. But if you intentionally did that, you're going to look like an asshole to whatever judge you're dealing with. And the attorneys you're working with are going to think you're an asshole in the future. But more importantly, where'd we get around that you're a fucking jack off? So no, you wouldn't want to do that. That would be really, really, really bad. I'm just saying, I wouldn't want to do that. And you always want to be seen as fucking daddy big dick everywhere you go, because you should be. I don't want to be seen as fucking schmuck, private schmuckatelli. You don't want to be seen as that guy. So no, you wouldn't intentionally want to do that. Now, there might be a situation where you misspell an opposing, the plaintiff or the defendant's name a little bit if they have a common misspelling and it pisses them fuck off. Maybe you'll do that a little bit, but you got to be careful. You can get in trouble for that. Tejas Liber says there are 12 confirmed transferable M240s or Mag 58s on the NFA registry that aren't currently in government custody. Really? I didn't know it was that high. I thought it was like the M134 Gatling guns, where it was the miniguns where there were only 2 or 3 of there's 2 of those, and I think there's 2 or 3 saws that are fully transferable, and then I thought it was 2 or 3 M240s that were out there. So, Purple Cowhead says, I think attorneys have better things to think about. Yeah, we do. We do. I want to make sure I don't fucking lose. Blanco Boy says Kiwi Farms is posting that a class action lawsuit has been filed against Hambly. It's set to be filed Monday. Ooh, okay. We'll take a look at that here in a minute. And then Corey Boatwright for 50 subs. God damn. Nice. Woo! Thank you, Corey. Good to see you, man. Hope you're doing well out there. And another 50 subs. 100 subs. Whoa. God damn. Let's fucking go, chat. Let's go. Woo. God damn, that's good. Nice. Just crushing those grays and helping make keeping America green again, chat. We will make America green again, chat. We will. By God, we will have our home again. By God, we will have our home. By blood or sweat. We will get there yet. You know. Or you quote the great Patty Tarleton, blood and sovereignty forever. But god damn, woo! Let's fucking go! You're still great after all these years, yeah. Why did you totally skip over the lawsuit and only cover the state against Denver for their only cover the lawsuit against their Stendo ban? I didn't realize it was the assault weapons ban too. I thought it was just the magazines. I didn't know that part. So we'll circle back to that next week on Thursday. So I did not realize that. Amateur Iconoclast for wide sob. Oh. Yeah, look out, Grace. We coming for you. Oh. I don't know. And guys, Freebird, I don't know what to do instead of Freebird. I still haven't found the right song for Freebird yet. So we'll get one. We'll find one at one point. I promise. We'll find one. We just don't have one yet. Yeah, I didn't realize it was 2 suits, but thank you. And I saw your I didn't have a chance to respond to you yet, but thank you. Panama, yes. We need to do a remix of your outro. Use Erica. Yeah, no, like Steel Toe's already kind of ruined that. I can't use Erica. And it's also kind of ruined using Grun is Unster Fallschirm, which I think is like a better when they do the bass track to it and do the hard bass version of that. I think it's so much better than Erica in that regard. But yeah, no, that's all been kind of ruined. It's been kind of ruined. How about the guy that covers Freebird solo on harmonica? No. Oh, speaking of Panama, that guy who shot the protesters blocking the highway got 48 years in prison. Yeah, that's not really a surprise. What about Prussia's Glory? Oh, maybe. Sing the song for 12 years of play? No. No, but I could use that one recorder song where it's like do 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 do. I forget what it's called. It's called like jumping around or something. I don't splashing around. That'd be funny. Your Freebird could be 21st Century Death Squad Anthem by. Okay, I need to hold on here. What the fuck is this? Sounds 21st Century Death Squad Anthem. Thy Art is Murder. Okay. I don't see 21st Century Death Squad Anthem. I see Art is Murder. And I don't know what that is. Hold on. You know what? Oh, fuck yeah. This goes fucking hard. We'll use this. We will use this. Death Squad Anthem by the SS. Is this a troll? No, it's actually pretty good. Thy Art is Murder. Well, there we go. Oh, fuck. We'll use this. It's a fucking... The fucking music video, this goes hard. Use Holiday in Cambodia? Maybe. Yeah, we might switch. We might do that there. So... Can I use the Barbie Girl song? Maybe. So... Okay. Yeah, hold on here. This is pretty fucking good. We'll try this for a second here. This is pretty fucking good. Here we go. Fucking goes hard, man. Fucking like it. Let's get some subs. This goes fucking hard. I like this. This is fucking nice. I like it. It's not the best vocals, but I'm pretty good. There's a pop channel that sings YouTube songs or sings songs in Latin. I like that. I like that. Radcon Hazard gifting wide sub. I'll catch a copyright, and the most they do is demonetize the stream. So I miss Slipknot, yeah. Also, be sure to change your license to remove yourself from how tax rolls. Oh yeah, we'll get that done before the end of the month. So, but yeah, I never heard of those guys. They are like, that's awesome. I like these guys. So, you ever consider going on Dark Side Phil? That would be funny. No, I would never go on there. I'd want him to. I would never go to Phil. No, I would want to be in control. When you're like Phil needs to be like getting Phil, like you need to have Phil in a controlled environment, like a deposition, where he can't ever run away. And that's one of the things I think Phil is smart enough to know, that if he ever tried to sue people, depositions would happen, and Phil's locked in a room and he can't just quit or lie. So, yeah, I would never do that unless there was an opportunity just to, fucking spit roast him. So, yeah, that would never be. We'll work on that. Anyways, guys, got 45 minutes. We got to get to the show. We got to get to the show, guys. It's time. It's time. Also, it says, am I not live on Kick? No, it says I'm there. Okay. When you take away the Phil's options legally and ethically, yes. So, anyways, let's go. All right, guys. So getting into some stuff here. We're going to start with Russell Greer first. Russell Greer has his lawsuit against Viatron, his employer. And this, I don't think Russell understands what he's done here. But Russell Greer has kind of painted himself into a corner. I don't know why he did this. But this is, I don't know why he did this. This is so stupid on his part. But Russell Greer has agreed to enter into arbitration. And arbitration, some of you might say, well, wait, why would anybody agree to arbitration? Well, we talked about this before, like in the WWE lawsuit on Vince McMahon. Arbitration is something corporations use to abuse the fucking system in their favor. Arbitration, you go sit in front of an arbitrator and they decide your case. They take all the facts and you present them to them. And arbitrators, the way they're set up, they support the people who fund their system. Businesses and corporations. That's who uses arbitrations. We've seen that in different cases of, arbitration clauses that are out there. Disney tried to use the arbitration clause in Disney Plus to fuck that lady up. Fuck that family up where the lady died from the cooking. And it's going to be great. It's going to be great in that. And then the court's like, no, you can't do that. And there are times where these arbitration clauses, courts could find them unconscionable. But generally speaking, arbitration clauses are the best friend of whatever side has that contract. So Russell Greer voluntarily doing this. I don't why would you do this to yourself? But this is a notice and entry of order of a binding binding arbitration agreement. I don't know if Russell's an idiot. Well, I mean, he is a tard. But Russell, the notice of entry and order and stipulation of binding arbitration. I mean, courts don't care. Courts want this. You know why? It's off their docket. Done. Yeah, does he think it's kinky law bondage? Maybe, I don't know. I'm a patient. I don't know if he knows what it is. But there's a stipulation here, okay? And there's binding arbitration that's entered. And we'll talk about what arbitration is because they're going to go through it here in a second, okay? But it's a notice and entry of the order of binding arbitration. So they're agreeing to it. And the court's going to be like, great, agree. It's just like Denims and Ethan Klein. They agreed to something. They had a stipulation. Court's like, awesome. I don't want that. You guys go fuck off on your own time. So we get into this here, and this is the stipulation. So Russell Greer, who's representing himself, and Viatron, who has, if you guys weren't aware, Matthew D. Harden Esquire, they agree and hereby stipulate and agree as follows. So what are they agreeing with? Well, Russell Greer started this case. The parties desire to resolve all disputes between them through binding arbitration administered by JAMS and pursuant to the JAMS comprehensive arbitration rules, guys. And JAMS is like this is they are the premier in the world, and arbitration, mediation, it's all considered an alternative dispute resolution. In law school, you learn it's called ADR. So, it's different ways you can resolve stuff. You guys hear about like in the MLB, players go to mediation or arbitration for contract disputes and things like that. Now, in that situation, it's a little different. The owners obviously it still favors them, but those guys are walking away with something. I think Russell thinks that the arbitrator's gonna force Viatron to give him something, and I think he thinks that they're going to like see it his way or tell them like, oh, give him a couple 100,000 and tell them to fuck off. And that's not how it's going to work. It's not how it's going to work. And if you guys don't know who they are, Jams, this is them here. They are, super huge. They do arbitration, mediation. They do neutral analysis of things. They can be referees and special masters. They have all kinds of services they offer. And, alternative dispute resolution is a big thing nowadays. Courts love it because they don't have to do it. They don't have to do it. There can be direct negotiations. There can be mock exercises and consultations on things. They do all kinds of stuff here. Look at everything they do. And this is actually important here. So this is an unrepresented party notice. This is somebody for Russell. Like, Russell, you're getting free help here. You're getting free help. Russell, remember, I'm not your lawyer. Go find a lawyer where you live. But, this is for everybody else to learn. JAMS is a private organization that's not affiliated with anybody. But who's going to pay for it? The corporations. This is corporate-backed interest. JAMS or JAMS neutrals do not have a financial interest in the outcome of any matter. If they started awarding millions of dollars to people suing corporations, they would quit having any business. So yes, they do. JAMS is an administrator and provides services such as calendar management, billing management, arbitration administration, and other case management. Well, they get their cut of the action. They don't provide legal assistance to the parties in how they should present their case. They don't represent any party in any matter. There's no attorney-client relationship. Yep. So I'm sure Russell's going to tell them all kinds of shit. And if Russell's dumb enough to do that, I'm assuming Matthew, I haven't talked to Matthew Harden in a while, but I was like, he better call them and subpoena the information if Russell contacts them and use any of that. But yeah, if you require legal advice, go find a fucking lawyer. But anyways, you could submit cases. You're looking for mediators or arbitrators who are usually retired judges or fairly prominent attorneys who have a lot of experience in mediation and arbitration. So, for example, labor arbitrators and things like that. All kinds of stuff. All kinds of stuff. Yes, they are professional corporate bootlickers. They are. They are. Russell should have went with Jelly. Boo. Boo. Even Laney's like, boo. Boo. Yeah. And Edward's correct. If they started going the wrong way, they'd be fucked. And there's a lot of rules. They have their own sets of rules that you understand and acknowledge when you're engaging with them. They have like all kinds of rules. And it's actually really interesting. I've read through this stuff before. I read through it when I was in law school. I had a class on like negotiations and ADR stuff. And it was actually really cool. It was really cool. They have class action procedures. They have stuff for consumer cases, labor and employment cases, construction stuff, employment, all kinds of things, international rules, because you have international groups. And then, once again, as I brought up before, when you're dealing with parties in different places, you have conflict of laws and choice of law. That's not an issue here, but that's always a potential for a problem. But let's keep moving here. The parties agree that binding arbitration is the most efficient and appropriate means of resolving the claim. Why would you do that? Because you know what binding arbitration is, guys? To the maximum extent permitted by law, the parties agree to submit to final and binding arbitration on all claims, counterclaims, cross-claims, and defenses that were raised or could be raised in the civil action, meaning everything. This encompasses any and all arbitrable claims arising in favor of Russell Greer or Viatron from the beginning of time through and including the date of the execution of the stipulation, meaning any of them up to the point we sign this going backwards in history. Whether sounding in contract, tort, statute, or otherwise, regardless of the legal theory on which they're based. And they say to the extent there is any threshold of dispute as whether a claim is arbitrable, within the means agreement, the maximum extent permitted by law, the parties agree the question of arbitrability itself shall be subject to arbitration, meaning guess what? What's the arbitrator going to say? He's going to say it's subject to arbitration. So Russell, you have just like, you fucking raked yourself here, man. You fucking raked yourself for no reason. It's agreed that Russell submit any arbitrable claims within 14 days of the stipulations filed in the court. There. Okay. So what happens? Well, the arbitration will be administered by JAMS in accordance with their rules in effect at the time of the commencement of the arbitration, except as modified by stipulation. In the event of any conflict between the stipulation and the rules, this stipulation shall govern. A copy of the JAMS rules are obtained here, and that's so Russell can't say, I didn't know where to go, boss. The parties further agree that arbitration shall be governed by JAMS expedited procedures, meaning they're going to fucking railroad you, homie. You're going to die. You're like Ralph right now. I'm in danger. Yes. Matthew Harden's going to let this arbitrator fuck you to death. And he's going to sit there and smile. Selecting an arbitrator. A single neutral arbitrator selected in accordance with the JAMS rules. If the parties can't agree upon an arbitrator within 14 days of the commencement of the arbitration, so 14 days from the 24th, they have 14 days to figure this out. JAMS shall provide the parties a list of not fewer than 5 proposed arbitrators who are going to be from their area. Each party shall have 10 calendar days from receipt to list of such lists to strike 2 names. So you get 5. You're allowed to get rid of 2 of them. And then rank the remaining candidates in order of preference. JAMS shall then appoint the arbitrator with the highest composite ranking, meaning, well, who overall is the highest ranked. The arbitrator shall be a retired judge or an attorney licensed to practice in Nevada with substantial experience in commercial litigation. And that's how this works. You get an attorney who's well seasoned in this stuff, and that's how they roll. That's how they roll. So, Sweet Ralph Wakeham's reference. Thank you. But it really is like, I don't know what Russ. Oh, hold on, chat. I don't know why he did this. I don't know why he would agree to this. Yeah. Choose the form of your destruction. Choose and perish. That's what he did. That's what he just did here. And I have not been following Russell Greer. I've been too busy with other shit, guys. I have barely enough time to stay up on quartering and fucking Nick Rekieta and the fucking Ukraine thread on the farms. But the Denims thread. But like this, like, why would you fucking choose? If you were to Pleitsburg, the arbitrator don't give a fuck. Arbitrator don't give a shit about your plights. I don't care, sir. Sir, this is an arbitration. Not gonna help. Location in Nevada. At a site they use or anywhere else you could agree on, or as the arbitrator may choose. Staying in the civil action. They jointly request a civil action be stayed its entirety pending the final outcome. During the pendency, neither party shall seek any judicial relief with the subject matter of the stipulation, except as necessary to confirm, vacate, or modify or correct any arbitral award pursuant by applicable law. Seek emergency or provisional relief as contemplated by the JAMS rules or other applicable law. Now, here's the thing. You could agree to binding arbitration, but your state may say, doesn't fucking matter. You still have this right or that right. And that would control. Where such relief is not available from the arbitrator or enforce the terms of the stipulation. So they could come back to court and say, no, Russell, you agreed to this. And I have a feeling Russell's going to back out and Hardin's going to say, nope, you agreed to this. And now here's the thing for Russell, and this is something Hardin put together. Each party shall make efforts to stay any other pending proceedings, including administrative proceedings, grievance proceedings, OSHA or EEOC proceedings, or similar actions to the extent that they involve arbitrable claims as defined in this agreement. Now, here's the thing. OSHA and the EEOC are not bound by any of that. So, like, there may be no appeals on things. Generally speaking, they don't care that you have binding arbitration because that's not their problem. The government never agreed to it. So the advancement of cost. They shall advance all costs associated, not limited to the filing fees, the arbitrator fees, and expenses. Now, this is where people like Logan Paul have fucked up, where they've agreed to arbitration. Well, if everybody signs up for arbitration, you may not beat Logan Paul at arbitration, but it's going to cost him so much fucking money because it's like, you know, a couple $1,000s total to get this all done. So, like, all these people suing him for the crypto shit, you know, 10,000 people doing that at like $2,000 a pop. That hurts after a while. And then such advancement will not prejudice their right to seek reallocation of cost in the final award. Yeah. So the prevailing party, attorney's fees and costs. The non-prevailing party shall be responsible for all costs and expenses, including reasonable attorney's fees, expert witness fees. And they could go hire a bunch of experts, Russell, and fuck you to death with them. You're going to get airtighted, homie. You are going to get airtighted. It's going to happen. It's going to happen. And you're on the hook for all those costs. You're for the costs that were prepared by in advance in connection with the arbitration. You're going to be on the hook for the arbitration fees. And guess what? You're going to get a full assessment. You are going to get fucked. Court costs. All costs not associated with the arbitration shall be taxed as part of a final judgment entered in accordance with applicable Nevada law. Discovery shall be conducted in accordance with JAMS rules. And that is true. You can still conduct discovery in an arbitration. That is not uncommon. That is not uncommon. Greencap says, my special master from JAMS was excellent. And they can be. But if you're suing, like if I'm suing like Microsoft and we go into arbitration, you're fucked. You are like, they're milking your prostate with the whole hand. Like you are not walking out of it. But they're like, overall, I would say it's not bad. But when you're up against like a corpo situation, you're dead. You're dead. So airtight, I'm gonna need a detailed explanation. Well, yeah, I you go talk to your mother about that. And yes, Bald Eagle's correct. Valve had to change their TOS to exclude arbitration after everybody sent them to arbitration. You know, they even forced people mid-arbitration to agree to the new TOS to keep their libraries. Yeah, but that's a problem. Arbitration could backfire if everybody agrees to start attacking you with it. Like, they could beat you to death with that club. But generally speaking, if you're the corporation, you're holding the club. The problem is if 100,000 people attack you at once, you can't smash them all, and you're going to get beat up really bad. So it's a thing. It is a thing, chat. Adam says, wait, can they issue subpoenas? Not necessarily issue subpoenas, but you can request, you can request things. And you can get all kinds of discovery. You can get document requests, interrogatories, requests for admissions, and depositions. So you could say, I want to talk to this party or that party, and the arbitrator is going to decide. It's no longer a subpoena, but the arbitrator is going to say, yes, you guys agree to come into these. These are the rules. I have full say. I can order it. If there's, the needs of the parties, complexities, the issues, and desirability of making discovery expeditious and cost effective. So, it's going to be a crash course discovery. It's not going to be super lengthy. So, as much as I will say, I've told Hardin this before. I think he needs to be careful about all the shit that he's doing in the Russell Greer, Josh Moon case and the Farms case. You're not going to be able to go fishing like that and do all the stuff he's been doing. It's going to be very focused, but that's part of let's get some discovery going, but the basic bare minimum needed. And normally corporations are okay with it because they're like, we haven't done anything wrong. And even if it's quasi wrong, guess who's got our back? The arbitrator. And then governing law. The stipulation shall be governed and construed in accordance with the laws of the state of Nevada, without regard to conflicts of law principles. The arbitrator shall apply Nevada law to any dispute. And it says, the Federal Arbitration Act shall govern the enforceability of the stipulation in any proceedings to confirm, modify, or correct awards. And there are federal laws that control on how arbitrations can be challenged. And there are times where you could get in there and say, like, this is wrong, that's wrong, if the awards are wrong or improper. And federal law governs that. But there are times where a lot of times you're like, I don't like this. Too fucking bad. Too fucking bad, chat. Too fucking bad. So arbiters are like judges on steroids and are unbound from legal requirements, pretty much. This user 44 says, how's Matthew Hardin involved? Well, Viatron, realizing he has experience in handling Russell Greer, reached out to him and hired him and retained him. So now he's pro-hawking in to come after Russell Greer because he's like a Greeritologist. You could almost call him the study of Russell Greer. You could call it derpatology. So he's a derpatologist. So yours was totally reasonable, though. They're not always, man. Talk to a lot of attorneys. They'll tell you arbitration fucking gay. The arbitration proceedings, including all submissions, testimony, and evidence, shall be kept confidential, except to enforce awards, comply with law, or comply with court orders. Arbitrable awards. The arbitrator shall render a final written reason award within 30 days of the close of the hearing. And the thing is, guys, this could be like 6 months from now. It could be 2 years from now. Arbitration has like its own course, and there are no deadlines. They can kind of get to it when they get to it. The award shall be final and binding on all parties, and judgment upon the award may be entered in any court of competent jurisdiction, including Clark County. Parties waive the right to appeal the merits of the award, except as provided under the Federal Arbitration Act or applicable Nevada law, which is not going to help Russell at all when he loses on this. When it turns out and is wrong, he's fucked. Authority of the arbitrator. Parties shall have the authority to grant any remedy or relief that would have been available to the parties had the matter been heard in court, including compensatory damages, relief, declaratory relief, and other relief. The waiver of jury trial. And this is in caps, so Russell can't claim he didn't see it. By entering into the stipulation, each party knowingly, voluntarily, and irrevocably waives any right to a trial by jury in connection with any counterclaim or defense subject to the stipulation. That means it's done, Russell. The entire agreement shall be here. The stipulation is not modified or amended except by writing by all parties. Counterparts, you could sign this on one or more counterparts, and that just means chat here. Like Russell could sign a copy, the attorneys could sign a copy, which is very likely what happened here, and then they get filed together. Or they can send that out, Russell faxes it back, then they sign it and then submit it. Not a big deal on that. Severability. If this provision of the stipulation is invalid or enforceable, the remaining provisions shall continue in full force and effect to the extent it works. Construction. And this is a big thing, guys. And this is the thing I've written when you write documents. Typically under common law, and there might be many state law cases on this, if a party constructs a document, any ambiguity is construed against the drafter because you're the one who put it together. So it's your job to make sure it wasn't ambiguous. This stipulation has been jointly drafted and negotiated. In any event of ambiguity, it shall be construed as if jointly prepared by the parties, and no presumption or burden of proof shall arise favoring or disfavoring any party. So they're basically saying we're not, you can't hold it against us if we mess up. They've literally insulated themselves every way they could. This is really bad. This is really bad, Russell. Adam says, wow, you sign away your rights? Yes, arbitration and ADR is a tactic used by many organizations. You know, it's a way to fuck with people. So, but yeah, spread them cheeks, Russell. This is not going to go the way you anticipated, brother. Let me tell you what. So, good job, Russell Guia. Good job, Russell. And then we're going to get into, real quick, we're going to get into now. Russell Greer filed his his answer and defenses to the counterclaims. Oh, we moved that. Oh, I forgot Russell had his fucking. And it's funny, Russell tried to claim that's his address. I'm like, the guy doesn't live there anymore. So, whatever, Russell. Whatever. I'm sure he'll cry. So, this is funny here. I love how Russell does this because now Russell says, they are attempting to weaponize the legal system to punish me for seeking protection from harassment. The fatal flaw is the doctrine of unclean hands. That's an affirmative defense for you, Russell. He cannot claim damages for uncompensated time spent defending himself in Nevada when those were necessitated by his own decision to stalk, harass, and interfere with the relationships in Winnemucca and elsewhere. I don't know if Matthew Harden's found this out, but I wonder, since Russell's now again citing case law, is this valid case law or is this AI generated? But you don't ever put your fucking case law in the introduction. So he says denial of improper purpose. This is the way you do this, chat. We've seen this before. When you come to these, like paragraph 1, we deny all claims. Paragraph 2, we deny all facts and allegations. Paragraph 3, you deny all facts and allegations. 4, without knowledge. 5, we agreed that it occurred in Nevada, but we don't agree to anything else. This is all admissible stuff now. This is all admissible. These are Russell's statements. These can be used as his own statements. Plaintiff denies the Nevada order was filed to evade jurisdiction. It was a defensive shield. He, talks about Harden digging his heels in and seeing third parties and claimed that Russell was luring women to the desert. Well, you were. It was quite honestly starting behavior from a supposed licensed attorney. Well, Greer warned Harden that he was seeking a protective order. This was a bluff to get Harden to stop. Harden didn't, so plaintiff acted on his promise. Well, then it's not a bluff. But it sounds like you're almost kind of circuitous, like you're kind of like roundabout admitting this is frivolous conduct. You did it to threaten him. You didn't actually want to go through with it. I mean, I'm just saying from reading that, that's what it looks like to me, Russell. That's what it looks like to me there, buddy boy. So, yes, J-Rock probably has some experience in federal arbitration because I don't. But yes, under Section 7, arbitrators can summon witnesses to testify and bring documents, and that can be enforced by a federal court. I did not know that, but thank you, J-Rock. That's awesome. So, any way you slice it, it looks improper. It does. And threatening action against another party in a civil matter is very much frowned upon. Justification. The Nevada court was the appropriate venue to seek relief for conduct occurring in the home state, including Harden's documented attempts to contact local officials with scandalous and immaterial assertions. No lack of probable cause. Plaintiff had a reasonable belief that a protective order was necessary to stop Harden's insane antics. I don't know how this is going to be considered here. We're going to get to it. But this is not how you respond, chat. Plaintiff did come very close to pushing for criminal charges against Harden for his relentless stalking, but Greer decided against it for the time being. You can't threaten parties with criminal action to strong-arm a legal settlement. Like, that's unethical. You can't do that, Russell. So now you're admitting to more misconduct. I mean, like, thank you. Matthew Harden's like, ching, thanks. Response to tortious interference. They claim they've suffered $75,000 in damages, minimum. The damages are entirely self-inflicted. If Hardin had restricted his conduct to zealous advocacy within the Utah copyright case, plaintiff would have not have sought a restraining order. Hardin had been told to stop on several occasions. Hardin has become so delusional in his conspiracies that Russell has committed some kind of elaborate scheme or is running some kind of criminal empire. Well, you are running a scam. That plaintiff had no choice to seek help from the outside. No damages occurred. Hardin has suffered nowhere near $75,000 in damages. Well, maybe. Plaintiff simply filed an application for an ex parte protection order. Hardin was only alerted to it because his clients are the world's biggest community of stalkers. He would be served with notice, though, Russell. Like, do you not understand how that works? Like, Hardin has the opportunity to respond. Although this is another example of you abusing the process. I was just going to file it and let it sit in secret. And then you would try to say, well, he's not showing up. The application was denied and Hardin alerted the court to this filing. That's all that happened. Well, if that's all that happened, are you really going to scream and cry about this being stalking? You drooling faggot? I mean, I don't know. Nowhere in that was there $75,000 in damages. I think punitive damages, you don't do this again. Documented interference by Hardin. It is you, Hardin, not Russell, who's committed tortious interference. As documented in the motion to disqualify, that you lost. That you lost, Russell. That you lost. These things you keep losing, and the court's going to take notice of those. It's all part of the case file. So the court will take judicial notice of it, agreeing that you did not commit. Like, that there was no valid reasons for it. Hardin proactively emailed a realtor. Like, none of this matters because the court already said this wasn't a motion. This wasn't a thing. Fetch didn't happen. Lack of foundation. Hardin's interference is based on a fraud theory involving the 2020 IFP records. Well, you did, yes. However, this court's dated March 31st specifically denied Hardin access to those records and found no significant concern. Hardin cannot claim he was investigating fraud when the court has ruled he had no legal authority to view those in the first place. Well, only the court determined that. Before that, he was allowed to. So you're going to lose again here, Russell. Response to the vexatious litigation designation. I am not a vexatious litigant. I defeated defendant's motion to dismiss. That doesn't mean that you're not vexatious, Russell. The fact the court denied the motion to view the records and denied his preservation order proves the opposition to Hardin's tactics is legally sound and meritorious. If anything, it's Matthew Hardin. It is you. It's you who is vexatious. Not really. Affirmative defense is unclean hands. We're in fucking Acerthorn territory, Chad, except it's not in all caps. Stalking and sabotaging business through defamatory emails to third parties. Justification and privilege. The actions in Nevada were legally privileged. Failure to mitigate. See, guys, tip for you when you do responses, you list out everything. Latches, estoppel, promissory estoppel, waiver. Like, you list out all common law defenses available. You list them all out. Failure to join appropriate parties. You list it all out. He didn't do that, so he's waiving these. Absence of disputable material facts. No reasonable jury standard. If you're going to file a motion to dismiss like that, you should file that first, but this is invalid here. Can't do this. Also, no fucking orphans. God damn you, man. God damn you. Signed, Ronald Greer. Minor fight. And there we go. Plaintiff bluffing a restraining order. I don't think you understand what bluffing means, Russell. So I do think it's funny, though. He says, none of this has to do with copyright. Funny enough, you have roped yourself with criminal charges. I'm sure Russell gets roped on at the truck stop all the time with ropes, a lot of ropes. So, this is just fucking stupid. This is so fucking stupid. Yeah, he does not understand what it means. From here, Matthew Hardin, this is filed on the 14th. Matthew Hardin comes right back and files a motion to strike. That's 4 pages long. So he wants a motion to strike. Um, and here's the problem, and I just kind of brought this up, and Matthew Hardin addresses it. This is like a hybrid motion between a motion to dismiss and a summary judgment motion. And remember, that's where you turn a Rule 12 into a Rule 12C, and that's almost like a Rule 56 something. But it doesn't comport with Federal Civil Rule 8, and it doesn't resemble any answer undersigned counsel has ever seen in 12 years of practice. And I keep forgetting Matthew Hardin and I have been practicing the same amount of time. Pretty cool when you think about it. Pretty cool. We're both young bucks in the system still. But yeah, it's a hybrid motion between an answer, a motion to dismiss, and a motion for summary judgment. Yeah, it's a motion, it's an answer, it's a summary judgment, and a motion to dismiss. Like, you can't file these all together. It doesn't work that way. And it doesn't put anybody on notice of what's in here. It's a fucking disaster. It says Greer hasn't responded to any of the counterclaims, factual allegations, and numbered paragraphs. And guys, what they mean by that, it's pretty simple. When there is a hold on here, where is the answer to the amended complaint? And this is a great example of it. When you guys are trying to see what are you supposed to do, this is what Matthew Hardin said here. So what did he do? You state paragraph number 1 that it's a legal argument or things here we deny. To 2, we can deny. 3, we can deny part of this. 4, we can deny part of it. And, we don't know what you're talking about for the rest of it. And you go through this line by line by line. Paragraph 25, we admit. Paragraph 28, we lack information, so we deny. But notice how this works here. You do every paragraph. You answer every response. You do every response. That's how you handle this. This is a proper response. Notice every paragraph. Every paragraph is responded to. Russell's thing here, this is just fucking gloppity gloop. And there's no way to keep track of it. There's no way to keep track of it. There are no general denial of allegations, much less a general denial in good faith. Instead, Greer raises fact-based arguments of his own, which he suggests mandate dismissal. Greer states he did not file parallel litigation to evade. That supposedly defeats counts 1 and 2, but Greer does not address the factual allegations in the claim. And if anything, his answer is a legal conclusion rather than a response of pleading. Or you could just, and Hardin brings up here, if Russell Greer is raising legal arguments for dismissal, Matthew Hardin gets the opportunity to respond in a properly filed motion to dismiss. And J-Rock, who's down in the great state of Georgia, says the judge is here at least required to restate the allegation and the answer and then provide your answer directly below. That's something, up here, I don't think that's the case. But every place is different. Every place is different, but you have to do it. The way Russell Greer did it, that was gloppity gloop. It's just garbage, hot garbage. And they say Russell Greer has failed to address everything from his intentional choice not to serve counsel with the parallel litigation and deprived defense counsel the opportunity to respond. To his admission, he was filing it in the state court because he was dissatisfied with the court's failure. To the allegation that the Farms and Josh were the true targets of the litigation, Greer nominally filed. And Russell asserts there are no damages. That's not a denial of any factual claim as a liability, nor does it put counsel on notice what factual issues might be there. All allegations related to damages are deemed admitted if they're not denied, and that's true. Remember, guys, if there's a paragraph and you don't respond to it, that's deemed admitted as true. So, for example, if there's 50 paragraphs and your complaint, your answer only starts at paragraph 51, everything before that will been deemed admitted. Just like in a default situation, you didn't respond to it. Ironically, allegations relating to damages are the only things Russell is bothered to deny. He says he's not a vexatious litigant. It says here again, Russell has not addressed the factual allegations. It doesn't even deny that the prerequisites for invoking the jurisdiction or award relief have been met. Instead, he states that unexplained and unidentified facts are in his favor. And they're saying that there are no genuine issues of material facts. Greer admits the truth, and this is true. Greer has admitted that any factual allegations are true. So he's saying everything Matthew Hardin said is correct. I don't think that's what you want, Russell. I don't think that's what you want. I don't think that's what you want, buddy boy, because you're admitting everything Matthew Harden said is correct. Are you really going to say that? But it's not quite that way because Greer challenges certain facts, at least in a glancing way. So he claims that there was no probable cause to, the counterclaim alleges that Greer had no probable cause in institute litigation, nor even a reasonable belief for probable cause. But Greer says he did have a reasonable belief for probable cause. And that's the thing here. He's claiming this, but he's also saying this over here. And you can't do both. You can't do both. You can't claim there's no dispute, and then claim there's dispute. Counterclaimants would ordinarily be happy to invoke that, but the answer is so unclear, there's no way to determine what the scope of any admission or denial is. Yeah. So the answer is incomprehensible. It doesn't put defense on notice of what issues are in dispute, and does not tee this case up for any resolution. And it says responsive pleadings, like answers, must state in short and plain terms its defenses to each claim asserted against it. And affirmative defenses, including those listed, must be affirmatively stated in an answer. And the proper remedy is to strike and require an answer. So they're going to throw it at the wall and tell them to do it again. If you plug this into ChatGPT, would it be discoverable? Well, in the SDNY, it might be, but I don't know about out here. But I totally think he did that. But even for ChatGPT, that was shitty. So I think ChatGPT would have done a better job. This court should strike through his answer and give him the opportunity to file pleading that responds. And I love this Bodied by Bella Boutique LLC versus Bodied by Bella. Russell be like, I'll body you. So anyways, they want another chance to do it right. And Russell Greer comes back and goes, Russell comes back and goes, see, Russell, I covered it up. So you don't live there anymore, but I'll help you fit a tampon, son. I'll help you fit your tampons. So Russell goes, I'm opposing this. I'm actually doing this now, chat, instead. We're going to follow each document out. There's been a bunch of responsive filings. So that's the game plan here. That's going to be my plan going forward, is we're going to respond to all the allegations as we go to them. I think this makes things a little cleaner and smoother and easier for you guys to understand. So Russell submits his opposition to the motion to strike. Plaintiff is tired of playing procedural games with an attorney. I mean, this is what happens. Oh, yes, I agree, J-Rock. From now on, I'm requesting AI stuff. From now on. He spent months dragging out the litigation. It's like, but you have to. The answer is comprehensible. The defendant's confusion is a choice. It's a choice. You just don't understand. You don't understand. You don't understand me, Dad. Russell's like, if you were smart, you'd understand me. I'm surprised Russell didn't type in here. Anybody who doesn't understand his complaint is gay. Defendants claim this is incomprehensible. This is disingenuous. Any competent attorney can easily understand the following points. I can't. I guess I'm not competent. Well, I guess there'll be the alliance of Russell Greer and Nick Rekieta finally. They'll be like, they'll meet hand in hand. They'll dab each other up. Russell Greer goes, Nick Rekieta, you son of a bitch. Oh, yes. Anyone who doesn't understand owes me a brothel. And this was like, Russell's like, no, everything I said. And if I'm Matthew Harden, I go, okay, well, fuck it. Plaintiff denied that was evading jurisdiction, saying it was a defensive shield. Documented justification, he's citing his disqualification motion that you lost. Oh, the talking in third person is yes. Well, I'll go through those. By the way, Flash wants me to come on, I think, to talk about this tonight. So we're going to have a hog roast over on Flashcast, chat. Don't you worry. So That is going to happen. Also, I don't know. Real quick, chat. Do you know what happens? Like every time I click on something, I get this, and then if I just refresh it, it brings up the thing. So, do you guys know why it's doing that? I don't fucking understand. Oh, this message is held for review. Well, let me review it. Show. Fuck you, Jeremy. All the orange is going up. So. Oh, Sarah, you don't know about Russell? Russell is trying to start up whorehouses in Nevada. Oh yeah, he's reading this. Oh no, I could see that. I could see that. But even ChatGPT is not doing good fucking answers to this. So I only see that the video is flagged by YouTube. Do you have an extension installed? Nothing new than what I've already had. I haven't changed anything. So, like when the Chinese army was infighting, that was happening all day. What? Oh, there's okay. Well, and it says defendants. Oh, hold on here. Where am I to? Oh yeah, here we go. Plaintiff directly challenged a $75 damage claim as self-inflicted. If Matthew Harden, with 12-year experience, truly can understand these plain English denials, that's a failure of his own training and education, not a deficiency in the plaintiff's pleadings. This shit will get you in trouble right here. You can't do that. You can't do that as an attorney either. That is not good. So, why did Harding give him a second chance by requesting a do-over? Because he doesn't know what's actually being admitted to or denied. So, and the court's not going to say, yes, the Farms wins on everything. Because the court doesn't know what Russell's technically agreeing to. Like, it's not clear. So, like, it needs to be fixed. Oh, Shinobubu says, turns out a Chinese brigade that Xi Jinping allowed to drown during a flood is kind of mad at the government. Ooh. The PLA AF, the ground forces element of the PLA. Because remember, chat, and I will say, as much as I don't like Ryan McBeth on his Ukraine shit, his apparently hatred for China, like I actually respect. I respect the game on that. But he does a great job explaining the PLA, the People's Liberation Army. If you don't know anything about them, it's the entire umbrella, and it's the entire like DoD is the PLA. And then there's like the People's Liberation Army Navy, the People's Liberation Army Air Force. And then within the Army, there's the People's Liberation Army. Yeah, and from there it gets even really weird. So yeah, I don't know about this brigade thing either, but ooh. The PLA has no allegiance but to themselves. Yes, they have written multiple white papers about what they're going to do when the CCP collapses. And what actions and what their role is in the, eventually when things transition. Plaintiff is not a lawyer, is not required to produce a document that resembles any answer Hardin has seen in his career. The court system is for resolution disputes, not a contest who could follow the most rigid formatting. I mean, it is to an extent. The plaintiff's answers provide more than enough notice in the issues in dispute. Pro se documents are construed to be no lesser standard than an attorney's. Plaintiffs never drafted an answer or counterclaim before and assumed that was the proper format. And requesting for leave to amend. Should the court find the answer is technically non-compliant, they respectfully, of course, grant leave to file a proper answer. Well, yes, they would do that anyway, Russell. Oh, shit. I'm not on the right screen still? Fuck. Okay, sorry. Sorry, guys. This right here, if Matthew Hardin with 12 years experience truly can understand these denials, that's a failure of his own training and not a deficiency. 20 minutes. Fuck you guys. It's hard to tell because I have the second screen up, but Russell's documents are so fucking retarded. It's like just looking at a picture of pig shit, and there's pig shit on the other screen. I don't know which piece of pig shit I'm looking at. Like, I've got this screen where it's got this, like what we're looking at, and I've got the Discord over here, or StreamYard over on this other screen, right here. See, there's like two separate screens. I'm looking at the StreamYard. I'm looking at the internet. Sorry, guys. Crystal, hello. I can't wait till AI is forced on me. I'll fight harder than Will Stancil did. So he wants leave to amend. In the conclusion, he says plaintiff is done with these gotcha games. Defendants are attempting to win by technicality because they can't win on the facts. Well, no, winning on technicality is what you do, Russell. Signed by Russell Greer. Minute point. Oh. So, you're not helping, Luke. You're not helping. So, moving on from there, the next thing for Russell Greer at this point is Russell Greer and Matthew Hardin. Well, remember, there were sanctions that were awarded. And from here, Matthew Hardin put together his sanctions response. I need more screens. Maybe we'll have more screens down in Florida. So anyway, he's talking about his rate and everything he did here. Matthew Hardin spent 1.3 hours time correcting errors caused by Greer improperly requesting subpoenas. Another 1.1 hours drafting and filing the instant motion for sanctions. This included time spent emailing the clerk of court and the court's order necessity to take action when Greer violated discovery stay. Because undersigned counsel invoices clients on the first day of every month for work performed, the work performed by counsel in the month of June ultimately resulted in an invoice sent on will result in an invoice sent on July 1st, in which had billed for 720 hours. Defendants have contemporaneously filed a declaration for Matthew Hardin saying an additional 0.4 hours, 4/10 have been expended on this filing, 20 minutes. To the extent the court wishes to order Greer to reimburse, the new total would be $840. So Matthew Hardin wants $840. And, Russell's going to go, no, I don't want to pay it. I don't want to pay. And Russell's come here to say, no, I'm not paying costs. I'm not paying costs. I'm not paying costs. Well, you are going to pay costs, Russell. You're going to have to suffer. You're going to have to suffer on the cost here, buddy. So ultimately, and this is where we're going to end for Russell, because we're not going to go through his support of the keeping his IFP sealed. No, that's our dog barking. That's our dog, Lainey. She misses 2.0 fiercely, and I need to give her some more medicine. I might do that at some point here. But she's been pretty good. I spent a lot of the day hanging out with her and then working on stuff. So they're saying, well, in this, Russell says, while the court has found a technical violation of the discovery stay, plaintiff argues the requested financial award of $840 is unreasonable and that a written warning is appropriate sanction under the circumstances. This is now the third time Russell Greer has been financially sanctioned. It actually should be the fourth time at this point. So it's a technical violation. No, it's a willful violation, Russell. It's a massive fucking violation. The court acknowledges sincere belief in good faith. Yes, but they said that that's not an excuse, Russell. You can't have a good heart and an empty mind. The court acknowledges plaintiff's sincere belief. Yeah, and it didn't count. It didn't count. They're saying, yes, we acknowledge you thought so, but you're a fucking idiot. Plaintiff is a pro se litigant managing a disability. It's not a cognitive, well, we don't think it's cognitive, but maybe your mom drank when she was pregnant, Russell. But no, your disability has nothing to do with your ability to read and comply with things. You just drool on fucking prostitutes because you're a fucking creep. It doesn't hurt that. And he does not have the administrative resources of a law firm to cross-reference every oral statement within a written docket. You can't read a fucking court order, buddy? Yeah, he needs to become a vexatious litigant. This might be it. Plaintiff relied on his personal understanding of the proceedings in good faith. Because the violation is not willful or malicious, a financial penalty is disproportionate. No. You were told not to do it. And the court's only authorized to award reasonable expenses. Matthew Hardin requests $840 for 2.8 hours of work. This is excessive. How? How is that excessive, Russell? I mean, like doing the math, that's $300 an hour, man. That's what I would charge on something like this. That's pretty reasonable. That's a pretty decent rate, man. That's a pretty decent rate. J-Rock says, reminder, Sean, feed the fish. No. Okay, so there is out in Pymatuning, that's a lake on the Pennsylvania-Ohio border. You could go feed all these carp that are in the lake, and we can go feed. 2.0 wants to go feed the fish there one day. I'm not Jeremy. I don't have fish here. I don't run Fish Auschwitz. That's in Jeremy's house. That's not the fish, J-Rock. But thank you for being here 32 months. But that's only $300 an hour. That's pretty reasonable. Harding claims 1.3 hours for correcting the error, which involved emailing the clerk. We had to do all kinds of shit. For an experienced attorney, notifying the clerk of an existing stay should take minutes, not over an hour. The task was clerical in nature and does not justify a high billing amount. Counsel claims 1.1 hours for drafting a motion for sanctions. Once the clerk was notified the subpoena was voided, the damage was fully mitigated. No, it wasn't. The choice to spend an hour drafting a motion was a tactical choice to multiply litigation, not a necessary expense. Yeah, you're not going to win here, buddy. The subpoena was voided immediately. No discovery was produced, and the defendant suffered no delay to their defense. An $840 bill for a voided email is a windfall, not a reimbursement. This is all fucking AI talking right here. This is all AI talking. Russell's not this good. The written warning is the least sanction necessary. Well, they have to impose the court least sanction necessary to ensure future compliance. You don't comply, Russell. You have never complied. You've done whatever the fuck you wanted. Plaintiff now clearly stands to court's interpretation of the stay order and requirement to strictly follow written docket entries over personal recollections of oral rulings. Well, you should always read the court entries, Russell. A written warning instructing plaintiff to monitor and read all filings and written orders more closely before the action would achieve the court's goal of deterrence. You should have done that anyway, Russell. You've already been told to do that. The sanction of 840 is punitive. Yes, it is punitive. It's to correct your conduct. You are a fucking feral animal. You only understand the boot heel, Russell. You understand nothing but that. You don't understand. You understand only the stick. You're ignorant. You're a hog. You understand nothing more. And yes, pay up, sucker. Pay up. Just get that fucking check in the mail, Russell. Instead, the plaintiff asks the court to written written warning as a sole sanction. I mean, like, so what happens the next time, Russell? It's always a thing here. So, well, it reflects a violation while acknowledging the good faith and actual minimal cost. There was no good faith, Russell. You were told it didn't, you had no good faith to display. Nobody believes you. No, there is no good faith, buddy. You're done. You're done. You're dunny. No, you're not entitled to anything, Russell. Oh. So. Yeah. So let's catch up here real quick on some things. Meinegger says I'm frantically unpacking Clyde right now. That'd be so funny to do. That would be so funny. Let's see here. Got that. Amateur Iconoclast says, there are any GAU 8s in private circulation? No, but there are a couple of N134 miniguns. There's like 2 of them. And they're like, they rarely trade hands. John Coleman says, use Bella Ciao if you're already making Merca green. Well, Bella Ciao is the song of the Italian Communist Partisans. So no, I will not use I will not use that song, sir. But thank you for being here for 25 months. You guys, really, the numbers are always humbling. Rancon Hazard gifting 1 sub. Thaddeus McThunderschlong said, didn't Russ get his ass handed him in the AGT lawsuit arbitration? Yeah. Yeah, which I'm pretty sure went to arbitration. So why the fuck would he agree to this? He's a dumb fuck. Blanco Boy says the quartering lawsuit is looking fake. Apologies for the interruption. No worries. No worries. You didn't have to provide that. Thank you for the super chat, but no worries on that. I would just any of these lawsuits, it's just somebody looking to make money, man. You know, like there's nothing you could do to Jeremy. Jeremy's just, he's a lolcow. They have tart armor. Anonymous says, try not to be too funny tonight. Don't want to cut myself while doing meal prep. I'll work on that. Shinobubu says prolapsed law. And Eagle Eric's like, Russell, no! Pretty much. And then Coffee Cat for 5 subs. We'll get in a woo. We'll get you the dog barking and clawing. All right. Thank you, Coffee Cat. Coffee Cat, brand cat. Danny Smith Thunderslong says the price of oranges is too damn high. It is, man. It is. Oranges are not cheap, man. So, run, Clyde, run. J-Rock says, arbitration part of his employment contract, Sean? I don't know, because if there was, there would have been a motion to do that and invoke it. But since Russell's agreeing to it, I don't think there was. And if it wasn't part of the agreement, then Russell fucking got tricked. And Russell Matthew Harden placed a rake on the ground, and Russell voluntarily stepped on it. I'll ask Matthew Harden and find out. So, Laney's pissed. No, she just barks at everything after a while. Fun fact, one of the M240s that's fully transferable is serial number 001. Really? That is interesting. Wait, why are we talking about quiche? Some quiche can be very good. Quarter Pounder's drinking and deleting all his YouTube stuff. Yeah, I will say somebody just sent me this, guys. Bearing. Whoa, guys, see this, man. Look what Bearing just said. Hey, Quartering, are you going to acknowledge Tism? Woo! Oh, no. Oh, no. Oh, somebody getting fucking roasted tonight, buddy. Let me tell you. But yeah, I don't understand why Russell did this. There's no incentive to do what he did. He dumped the DMs. Oh, my God. Slayer says, what's Tism? Tism was the Incredible Salt Mine. That was a show where Count Dankula, Bearing, and somehow they let the Quartering on, and it was the three of them just kind of bullshitting as like a podcast. That was actually pretty good at times. Like Bearing and Count Dankula are fucking hilarious. So yeah, it was really good. If they didn't have the Quartering on, I'd just listen to fucking Bearing and Count Dankula. It's really, really good. Really, really good. Yeah, it was a good show. Yep. Yeah, they haven't been done anything for a while now, but we'll get to those DM leaks, or I'll do it when we go on with Flash. We got to move on to Denims, though. I promised Denims. We're doing Denims. But yeah, I don't know why Russell did this. I don't know why Russell did it. It makes no fucking sense. No sense. It's 10:55 and Flash still hasn't started anyway, so it's almost 11 and there's still no stream. But all right, here we go, chat. This got filed last week. We didn't get to cover it because it wasn't available. But this is a request for judicial notice. And remember, guys, judicial notice is a concept where you can bring in things to a court and they will accept them as true because they're easily verifiable facts without requiring formal proof. Now, things are like what May 1st was a Friday. That's judicial notice. May 8th was a Friday. May 9th is a Saturday. So they're asking for judicial notice on a lot of things here. Well, guess what they're citing here? Chat? They're citing a couple different things. And Ethan Klein's wanting the court to take judicial notice of a bunch of stuff. And one of them is the video entitled "The Big, the Bold, and the Beautiful," which made a fair use reaction video to the audiovisual work Bowl Guy versus Parkour Girl. I mean, this is the Ethan Klein's work reacting to Matt Haas's work, and that's the Haas versus Klein lawsuit in 2017. That's one of those ones like foundational fair use case law that I have in my disclaimers. See the declaration of Rahm. Well, the neat thing about this, guess who was involved in that lawsuit with Ethan? We're going to scroll down here. Representing Ethan Klein. Let's go through some of these names. Some of these names, I don't know who these people are. Rahm. Wow. Rahm, you know, this guy has been Ethan Klein's fucking OG from the start. Isn't that nice? Isn't that nice? Ooh. Ooh. Wow. Wow, chat. You know, he's been there from the start. And Kwai Chibi Kaneko is saying, if you look at the original complaint by Russell, he talked about arbitration, how they want to do it, now they do. I don't remember that part of it, and I know the Farms has a good memory on that stuff. I'm not gonna lie, I have not been staying up on the Russell stuff. So I've just been reading the docs as they get posted. So I'll take your word on that. It's my bad. Yes, Flash, we will. I have the link. We got to finish up the Denim stuff. I got 20 minutes anyway. We'll be there, brother. We'll be there. We'll be there. Do you have the bearing stuff? You still haven't even started yet. I just refreshed. Nothing's happened. Come on. I'm over here showing all the oranges. Come on now. You do? Oh, good. I can't wait. I can't wait. Yeah, I'm dealing with Denims and Ethan Klein real quick. We'll be over there. I have the link. I have the link. Oh, you sent me the link for that too? I will take a look. So, but this is all the stuff that's been filed here. There's also a complaint filed in the case of Ethan Klein versus Frogan. They talk about the Frogan watch party video. There's also they're also taking judicial notice of the Caseytron thing. Is he going to be on YouTube or Rumble? He's going to start on YouTube and then go to Rumble because Jeremy can't hurt anybody over on Rumble. Jeremy has no balls over on Rumble. His dick ain't got the reach on Rumble. He ain't got the fucking, he's not long and strong. So they talk about here the orders of the case in the Reddit subpoenas. That's getting judicially noticed. Oh, man, they're just judge. Take a look at all this shit. Documents subject to judicial notice is public records. And now the court doesn't have to take notice of things outside of its record. But you can tell the court, Your Honor, we would have the court take judicial notice of the filings in this case. And the court, without hesitation, will say, I take judicial notice of it. Now, you might say, well, wait, wouldn't the court already do that? Yes, but it's called belt and suspenders. You always just ask for it. You always ask for it. But anyways, the court could take judicial notice of pleadings filed with the court. Yes, in this court. They say, though, but these items are all public records below. Yeah, but it's not in this court, though, in this case. Is Flash leaving the stream on YouTube tonight? Until it goes to Rumble, yes. But he's going to Rumble, that way he doesn't get attacked. He might go to Kick, I don't know. Bringing in the big, the bold, the beautiful. This is good because you're giving a judge, look, judge, if you don't understand, here's a crash course. Here's what another court found to be fair use. This is fair use. We are the epitome. We litigated the defining fair use case that everybody cites to on the internet. And it's critical for that. Like, there's nothing wrong with that. There's nothing wrong with that. Smelly One Boom says, Muslims, Brotherhood, let's go. No bueno bots. Muslims Brotherhood, no bueno bots. Muslims, brother. Thank you. Well, you guys can take care of him. That remember that spam's the only thing I don't like. Yes. Yeah, Jeremy's attacking me. Yes. Sorry. He's like Destiny. He's got the Pajeets working for him. So he's trying to cite all these things here. He wants to cite all of this. The complaint and the Majid action. Oh, we got all kinds of bots now. The watch party in the Frogan action, the watch party in the Casey Tron action, the 429 order where they got the fair use factors lost. So the up and remember, this is Reddit fucking Denims over now. And then as this goes on here, guys, this is just beating the shit out of Denims. And then yesterday, Denims responded to Ethan Klein's filing last week. He did. He crushed these bitches. Why? In support of motion for judgment on the pleadings. So remember, Denims has said, I want a judgment on the pleadings. Motion. Ethan Klein gets to answer on, and then Denims gets finally back. She gets to hit the tennis ball back. Reply. And now we're done. So what are we gonna do? Well, June 5th. It's kind of fun. It's just like the date of the Brokeback HRO. It's gonna be that day too. It's gonna be a couple hours after that happens, but yep. Yep. Um, so here we go. They're basically saying, no, it's true. It's fair use. So here we go. We're going to get to it. Notice they have having a short table of authorities isn't necessarily an important thing. Like, you can't just judge it based on this. But I think it's a sign that they know they're running out of fucking road because they don't have support now. Like, they don't have a lot they're relying on. Now, notice here, Denim's use of the nuke in her live stream is fair as a matter of law. In opposition, Ethan Klein engages in a hyper-technical exercise. Yes! Yes, imagine that. In the law, it's about being persnickety and hyper-technical. It's all about semantics. Yes! That's what the law is. What do these words mean? What does each word in this mean? That's what we do. That's what we do. We're big faggots about this. What is the meaning of the word is? Yes, that's what we do. That's why someone want to kill us all. We've earned the reputation. We've earned it. Come on now. They're chock full of misdirection. I don't know about that. Named at demeaning the nature of her criticism. Well, yeah, that's fair. Falsely speculating Denims had truly intended to criticize the nuke. She would have done it differently. Actually, she would have. But the question before this court is not how it might have been hypothetically fair. The central question is whether the occurred was sufficiently transformative. But they're pointing out why you're not. Ethan resorts to splitting hairs. He's splitting some big old mother effing hairs, let me tell you that. He's splitting a lot of big old hairs there. And then it says Ethan must recognize it as no legally supportable retort to Denim's showing that her live stream reactions have vastly transformed the use of the nuke. It's not, though. And once again, they're relying on the 4 hours or 2.5 times the length of the original. Criticizing the film's production quality. Yeah, not really. Stop, Start, Rewound, or took down the nuke at over 200 separate points. Featured a live chat panel so viewers can respond. None of this is going to help you. The court need only look to Ethan's own allegations, including that Denim's viewership included Ethan's fallen fans, who rather than comprising a potential market, go out of their way to avoid giving Ethan views on the H3 channel. Yes, but as the Reddit mods told us, it's hate watching. The markets are not coextensive, but rather diametrically opposed. Yes, but hate watching bridges that gap. And they say the Section 107 factors taken separately and undoubtedly, when considered together, weigh in favor of finding fair use. No, they don't. So when they say it's highly transformative, It's not though. It consists of a live stream singles format with a live chat panel over 200 stops and starts. Notice they don't talk about the timing of this, that she watched it literally as it went live, not a day later, not 6 hours later. She did it as it was premiering. She did this, and that's a big problem for Denims. So, so it just doesn't work this way. She discusses production quality, responds to Ethan's scathing criticisms of Spiker and Twitch, disputes Klein's broader political statements, conclusions, and discusses geopolitical issues tangential to Israel Palestine. I have not listened to Denims, but I can't imagine she has anything to say about fucking geopolitical issues. Holy fucking shit. And it says that the reaction was broadcast in a live stream format where the nuke is an edited video. Ethan does not meaningfully dispute Denims showing the nature and format of a reaction rendered as transformative. And they cite the Stebbins case, Acerthorn again. They go on to cite, they point out that the full length, unrehearsed reaction was transformative for in the Stebbins case. But remember, Acerthorn lost that case. Acerthorn was suing, and it was very different. It was very, very different. And they point out, though, while Ethan Klein devotes significant ink to parsing and citing the contents of the critique, as if she were a student in debate class, claiming her reaction is not sufficiently thorough and sophisticated to be considered transformative is settled that you don't need to be accurate or well executed. And they say that, whether it's sufficient to render the transformative use under controlling legal principles. And they cite Matt Haas in the Ethan Klein case there. And they say applying a surgical and pedantic approach, which that's what we do in the law. Once again, this is what we do. Ethan implies it would come close to endorsing the right of rigid, bright line approach to fair use. Not at all. Not at all. Notice they aren't addressing anything here. The function and purpose of Denim's reaction was to disagree with the nuke. And Ethan admits that Denims used the nuke for the exact opposite purpose of the nuke's original purpose. That's not what they meant, and that's not how they said it. These guys are struggling to point something out here. Ethan addresses neither its admission in the complaint nor the undisputed fact observable from the stream. Denims served an utterly distinct function, and thus Ethan concedes it. What about Denim's statements that she was doing this to fuck Ethan out of money? Have they addressed it yet? And it says TEI reverses courses. TEI reverses courses and claims the purpose of the works overlap. They do. The court need only view Denim's live stream consistent with the real-time recognition reviewers want to watch someone who would disagree with the nuke. Yes! So they wanted to watch the nuke with somebody who would. Wow. Wow. Like, you're admitting the point. You're admitting the point. This was meant to fuck it over. On this particular note, what Denim says or thinks or feels is relevant to the fact of what Denims did. Yes, you're why would you agree to this? I get it. You can't ignore it, but why would you agree to this? Denims, your lawyers are well, to be fair, her lawyers aren't retarded. They're boxed in and they got nowhere to go. So Denims is kind of fucked. This is like those movies where the guy gets boxed in by the advancing enemy and he tells everybody to run and he locks the door behind him and then he gets ready to start shooting and they just drop him right away. Like Denims is not I'm saving everyone, dead. That's what's happening here. There's nothing they could do. Guys, please don't spam. That's the only rule. Please do not spam. Mystery Sniper, I have one rule. Please don't do it. This is what Ethan contends a use can't be transformative where the defendant copies more than is necessary. Ethan ignores there no live stream reaction media. Will the actor pre-select exactly how his subject will be discussed prior to the use? Really, you know what would make that easy for you, Denims? If you didn't watch it live while it fucking premiered. That would be the fucking problem. And that is your problem here. That is your problem. HIV1 says, "Does Denims pick lawyers? Like, no wonder why she only bags gnomes." Her lawyers are good. They have bad facts, and with bad facts, you can only make bad arguments. So I'm sure her lawyers, if they were prosecuting this, would be very effective. But that's not how that works. Like, these guys are good. They're not idiots. Not like the Reddit lawyers where they got a fucking activist goober who's never went to law school. The Redditors fucked up. Denham's hired a good attorney. Like, they just can't do anything. It's just you can only do so much. Can we spam oranges though? No. They're saying this would undermine the media forum. Moreover, it's not disputed Denham's reacted to the nuke, not specific portions of it. Her stated purpose is always a reaction to the full film. The idea of live reaction to work was simultaneously call out only pre-selected bite-sized aspects, produces a catch-22 for any creator engaged in live stream reaction content. No, it doesn't. You watch it later. You watch it later. You watch it later. Because you can do a live react, a blind react. You just can't. Doing it live doesn't fucking help you, man. Doesn't fucking help you. It doesn't fucking work. Um, it just doesn't fucking work. It just doesn't fucking work, guys. So it doesn't. It doesn't at all. Well, that's why most reactors wait a day or two before capping. Kite says, "Watch it later. I'm so confused." Well, like Denham's watched it live. Like Ethan Klein set the nuke as a premiere. So when you do a premiere on YouTube with a pre-recorded video, you can air it at a set time or make it a lot like a premiere, which means there's a live chat going and all that. Ethan set it at a specific time and gave everybody notice when it was going live, and she sat there and basically did it live. If the repetitive speculative claims she sought to criticize the nuke, she would have watched it alone, prepared her commentary, and then posted her critique, must be rejected. It doesn't say what have been done to accomplish a fair use. The analysis considers whether the use in question is fair. They were pointing out what you could have done to comply with fair use. Yours was not fair. So, um, can you leave us here when you go to Flash? No, I'll just cancel. I won't redirect if that makes you feel better. Um, it says the lengths of the nuke that 70% of its total runtime was played uninterrupted for 30 seconds or longer during the reaction is confounding. First, it implies bright line rules apply when none do. No, but if there's no bright line rule, we have you're way past any limits of decency. Second, to react to nuke Denims need to show meaningful segments of it throughout. Yeah, and then yes, and playing 30 seconds to work the pause and critique is what Ethan claims falls within fair use. And they go back to citing the Matt Haas case. And the 70% metric is arbitrary on its face. Ethan marshals no legal support or argument for why that statistic is relevant. Because that's a fucking lot. 70% of something is a lot. That's more than 2/3. It's almost 3/4. So the reference to Denham's use as a watch party or group viewing session, implying an uninterrupted rebroadcast is grossly misleading. It pretty much is, though. The semantics lack legal significance, and Ethan's focus is similarly telling. The court's review of Denham's reaction will dispel any notion that she merely hosted a watch party for the public to watch a broadcast of the nuke, but you did. Nor in the Matt Haas case define what the court meant by group viewing sessions, or remotely suggest all viewers where a group gathers to view a reaction are not fair. And they talk about whether a watch party is not remotely dispositive. And they say there's an objective inquiry into what use was made, what the user does with the original work, and is not dependent on subjective intent. Well, her intent defines what she does with the work and what use was made. So yes, the intent of Denims is important here. It must be for this reason that Ethan resorts to deception, misrepresenting the court, the contents of the statements relating to her reaction. That's not true at all. And Ethan claims Denims sought to siphon views away from the nuke by telling a chatter, if you want to enjoy it, come watch this party, come enjoy the watch party somewhere else. Yeah, I mean, and this is what they try to say, like, this is all about what happened here in Japan. Don't bother Hassan. Don't go bother my daddy, Hassan. If you wanna watch it with someone else who's already watching, come enjoy the watch party somewhere else. Yeah, okay, yes, come watch it hot and fast with me. Nor does any commercial aspect of the use outweigh its transformation. Ethan emphasizes Denim solicited subscribers and donations, but fails to address the undisputed fact that Denim solicitation of subscribers and donos are not unique to the nuke. No, but in this case, she made a lot of fucking money and she knew she would make money. Intended. Denims was clearly leveraging her reaction and her performance as a reactor. And while reactions vary in terms of purpose and the extent to which they rely on copyright material, once again, they only have the Matt Haas piece to hang their hat on. They're hanging their Matt Haas hat here. That's all they got. Denham's reaction delivered a starkly different purpose. It was structured in a starkly different format and incorporated only the extent of copyrighted material to which she was reacting. The nuke is a complete subject, all of which neutralize any alleged commercialism. But she didn't though. She wanted to fuck him over. Um, and they say finally Ethan fails to rebut the explanation that when considered through flexible into the holistic lens, her use becomes all the more fair. The fair use is an equitable rule of reason. Yes, it's a rule of reason. What's reasonable? Denham's reacted to a 102-minute documentary about the Israel-Palestine conflict and related ideology for which a majority of its runtime castigates both Denham's political ally and the two streaming platform Twitch. Okay. The nuke targets Denham's insofar as she, like Piker, is a well-known alleged alt-left ball-watching communist whore who sucks Palestinian and terrorist cock, who generally promotes left-leaning political ideologies. It even features clips of Denims from Twitch in which she joins a panel discussion with other active live streamers during the section that attacks Twitch as a platform that supports far left-leaning political voices. In other words, Denham's reaction to the nuke was in the nature of responding to criticisms about her politics, and the platform that sponsors her. But she could talk about those parts, not about all of it. She didn't have to talk about the whole thing. It's the problem. Oh, so yeah. Anyway, it says here that oh, hold on. What is I hear what the hell am I hearing? Oh, that was weird. Like I had a Twitter tab up, and it was like some dude going to town with a fucking AK, and I was like, "Where the fuck is the gunfire coming from in this lawsuit?" I guess Ethan Klein is wiping her out, but goddamn, not that bad. So, no, it wasn't Flashcast. I don't have that up. And it says Ethan does not meaningfully respond to this. Ethan claims a public interest in the conflict does not assist Denims. Well, they point out the Supreme Court and the Harper and Row Publishers versus National Enterprises. The Supreme Court didn't purport to undermine Denham's port, not remotely. I think you misread that because it's been a while since I read it. And they say Denham's contention, which finds support in public case laws where political or social or moral debate undergirds the subject matter of a work, especially where the work is informational in nature. Fair use protections increase. Is she really informational? She's a stupid whore. Yes, Jeremy Hambley's faulting is so powerful you can hear it all the way from Ohio. So they go on to cite the Hustler case with Jerry Falwell, but that's a little different here. And they say the nuke is not within the core of copyright protection. I mean, they're going to go through the factors here, but a factual and informational mosaic of other people's copyrighted material. The nuke is light years from the core of intended copyright protection. It's not, though. It's not. Ethan has no response to this other than to contend the nuke is creative. which is inapposite as that case concerned aesthetically and creatively shot photography, not a documentary about geopolitics and current events. And it says Ethan argues that Denims conducted a reaction just after Ethan released a nuke. That is immaterial. No, that's actually pretty important. That's pretty important here. The fact is, the nuke was published, and from that moment, anyone could have watched the nuke on the H3 channel. When it was released, anyone, including people who don't like Ethan, like Denims, and presumably hundreds of thousands of Ethan supporters or anyone interested in watching the nuke did just that, which would include hate watchers. Which would include hate watchers. For these reasons, the second factor weighs heavily in Denham's favor. It doesn't, though. Um, it doesn't. It doesn't. Was Denham's use was reasonably tailored? Denims could have only selected pre-selected slices if her intention was a reactive critique. Um, yeah, I mean, but the problem is she did it live, like as it was going, so there was no time to prepare or take notes. That Denham's commentary on the content of the nuke persisted until the end of the film supports her position. She was reasonably tailored. This is not going to work. It's not going to work. And they say, without featuring the original clips, live streams would have lost utility as critical commentary. Without featuring original clips here, Denims. You say clips. You didn't do clips. You literally fucking ran the whole thing. And it says the existing copying was necessary to the critique. But it wasn't here. But it wasn't here. But it wasn't. It wasn't, though. Oh, Clyde is getting all fired up from Laney. So, oh. Ethan's cases support Denham's logic. I don't think they do. To accomplish the intended format of a real-time live stream reaction, Denims could not have only selected portions. Because live stream reacted all the nuke required, showing all the nuke, the third factor is in her favor or at worst neutral. Denims might go she might get 1 out of 4, or she's going to get 0 for 4 on this. She's going to go 0 and 4 on this. She's not going to win any of these. I don't think. Denham's use did not cause any cognizable harm. Okay, well, they argue that it was transformative, resulting in a different viewing experience, and it drastically undermines the claim. So market substitute. So, and they point out though, well, yeah. So it says, where use here is so transformative, the consumer cannot have a similar experience. The effect on the market decreases. But it says Denims could not have usurped the nuke's market because their target are not remotely the same. But you just said anybody above. You cite this that anybody could have watched it. Anybody could have watched it. You said anyone could have watched the content. But now you're saying it's different views. Which one is it? Which one is it? The nuke is designed to critique Hiker and Twitch performances here. Like this just and that Denham's an allegedly a loyal and ardent and cultish defender of Hassan. Yes. Who leads from his audience? He does. And the snarkers are now opponents of Ethan. Yeah, they are. And there's no question Denham's viewership and Ethan's are diametrically different, but they hate watch. And Denham's, the allegation that she proactively avoids watching the content means alleges the snarkers, which consist of people Ethan contends are not some of Denham's audience, are motivated to deprive Ethan of views and revenue. Belie Ethan's claim that these individuals in any meaningful mass would have watched the nuke and thereby given Ethan views and revenues, but for Denham's live stream. Yes, they would have. They would have watched it and then come over and fucking cried about it. It says Stark users, however, did not want Ethan to receive any views. Ethan's claim that Denham's views did not wish to support the nuke resolves any doubt. Denham's cannot usurp a market that, according to Ethan's own allegations, does not even exist. It does exist, though. There's hate watching. We know it exists. This judge is going to fucking see through this. Yes. Hate books are valid. Yes. This is all conclusory to them. Yes. But, like, we acknowledge there's hate watching. You're gonna have to acknowledge that. That is a thing. If Denims and all these people didn't show up, people would have watched it live on Ethan. They wouldn't have waited. Ethan admits the audiences do not would not overlap. They do. They would not have watched the original Nuke. Yes, they would have. And given the contrasting ideologies, would give Ethan views, but they do. They hate watch him all the fucking time. The allegations leave no genuine doubt that Denim's viewership contained people who did not ever intend to watch the original Nuke on the H3H3 channel. Yes, they would. Yes, they would have. Yes, they would have. Um, they would have. Um, they would have. They would have. 100% they would have. I do like how they say this. Yeah, hate watchers are your biggest fans generally. Yeah. Yes, very true, Keopathic. Ethan points to either cherry picked or out of context statements. They're not out of context. You know, they point here that the import of this handful of sporadic comments by viewers is both belied by Ethan's allegations. Indeed, they allege the H3 productions where the nuke was posted had 5.49 million subscribers. Meanwhile, Denim's live stream reaction at its peak was seen by just 45,800, and which is less than 1% of the subscriber base. That doesn't fucking get you anywhere. That doesn't get you anywhere. They say this is all immaterial and it neutralizes any adverse weight on the market. I mean, that's a lot of fucking views. 45,000 views. PPP is right about Ohio. No, he's not. Um, And they say for these conclusions, they want to grant the motion. And notice here, you guys, people made fun of this, but yes, Ethan's opposition memorandum exceeded the 7,000 word limit by 600 words. You pick everywhere you can to fight your guys. If you're going to get persnickety and melanated, like you get melanated in the rules. But it's funny they cry about the rules, and then down here they're citing the rules. That's very disingenuous. Um, Footnotes don't always count, but I don't know what the local rules say. So, but yeah, that's it, guys. Fucking Denims, that's toast. She just pulled her fucking ripcord on her parachute, and there ain't nothing there. The dead cord, and she ain't got no spare, and it ain't opening. So she's just thud. She's gonna auger right in. She's gonna auger right in. Ag says that's very Reddit tier. I mean, it is though. But you know what? As lawyers, you fight over that shit. That's what we do. We're dickheads about it. Jeff Jubin says, I heard the Cleveland rocks. It does. It does. So, no, she pulled out an anvil. Yeah. But yeah, Denims is toast, guys. There ain't nothing there. She's in free fall. Denims, you should be settling. You should be trying to settle right now. There's no way out of this. So, ask Ethan if you turn over all the Reddit mods, will he take it easy on you? He might. He might. Just a thought. That's not legal advice. That's just strategy and consultation. Free consultation. I would just do that. I would just do that. Okay. I would just do it. It doesn't rock enough to keep me around. Well, I love 2.0 and I'm willing to go where she goes. I love her that much. So, so, so he's gonna fight till the end. Yeah, but if Denims gives up the Reddit mods, he probably won't. So, so yeah. The ripcord was deck cord. Blew herself in half. So no, she's toast. She's toast. So we'll know in June, guys. We'll know in June. So it'll be fun. It'll be fun. So so even call potentially criminal. Yeah, thank you. All right, guys. With that said, we're gonna wrap this up. But yeah, Russ Greer, you gave Matthew Harden a free win, man, for some reason. And then Denims, good luck, sweetheart. Good luck. Good luck. Hassan ain't coming to save you. The son ain't coming to save you. You're probably on. He's probably got you on red right now. He ain't helping you. So, so chat. I will see you tomorrow. Well, maybe tomorrow, but Monday. And remember, until next time, guys. Yeah, no use hardened. It's super effective. Yes. Thank you guys. All the super chats, all the support tonight. I appreciate it. Thank you guys. Please subscribe. I would appreciate that. 27,215. We're making our way up the mountain, guys. So thank you. And I'll see you guys later. Remember till next time, chat. Just because you did it doesn't mean you're guilty. Although Denims, you are absolutely guilty of copyright infringement. And Russell Greer, you're guilty of being a retard. So good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even
Happy Mother's Day, everybody, to all the moms out there.
and even talking the law. Whatever you do, just don't talk to cops. Even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy?